Okay, Assalamualaikum warahmatullahi wabarakatuh. Good evening, everyone. My name is Naila Shafira with student ID 14012133347. And today I will present uh, my group's work about enforcement of justice in Indonesia. So the topic outline is the first one is theory and concepts of justice, and then we will discuss about the principles of formation of equitable legislation. And then we will discuss fair law enforcement in institutions. And the last one is cases that have been decided by a court and have a fair decision. The next slide will be presented by Syakila.
Okay, let me introduce myself first. My name is Andi Syakila NM with student ID 140121333. And now I will explain about the theory and concepts of justice. According to the Indonesian Dictionary, justice is a relative concept that refers to a decision or action that is based on objective norms. It doesn't mean that everyone is equal, but it does mean that a decision or action is based on these norms. The concept of justice varies widely from place to place. Each community has its own set of rules and regulations regarding the scale of justice. In Indonesia, justice is regarded as the basis of the state, and it's a set of values that aims to live together as a community. The 5 principles of Pancasila are designed to guide people toward living together as a society. The core values of justice must be realized to realize the goals of the state, which are to provide for the welfare of all its citizens. The values of justice are also the basis for the international community's association with nations. They promote the idea of living together as a society based on mutual respect and independence. And next slide maybe will represent.
My name is Naufalfaris Andrinesisto. My name is 14012131167. So I will explain about the principle of information of equitable legislation. So about the principle for the formation of laws and regulation, it is explained in the Article 5 of Law Number 12 of 2011. And there are 7 of these. And these principles are, first one is clarity of purposes. This principle states that every formation of legislation must have a clear goal to be achieved. Second one is appropriate institution or forming organs. The concept of statutory regulation states that all ways and regulation must be made by an authorized entity or institution. This means that if a regulation or law is made by an unauthorized entity, it can be void or cancelled. The third one is the suitability of the type, hierarchy, and the content of the material. The content of the material should be following its type, hierarchy, and function to be considered a suitable fit for legislation. This concept explains that the type and structure of laws and regulations should be considered when drafting legislation. So, for one, that it can be implemented. So, the concept of the legislation states that very form of legislation should be considered the effectiveness of its provisions in society. Slide. The fifth one is usability and effectiveness. The concept of effectiveness and usability explains that legislation should be made to be useful and effective in regulating the lives of the society. And sixth one is clarity of formulation. The concept of clarity of formulation also states that every regulation should meet the necessary technical requirements to be effective. This means that it should be clear and easy to understand, so it is implemented. Implementation can be carried out without causing an unnecessary interpretations. And last one is openness. The principle of open legislation states that laws and regulations should be made and enacted transparently. This means that everyone has the opportunity to participate in the process of drafting and implementing legislation. So the next slide will be presented by one of my friend.
Hello, my name is Rifqi Alpharizq P. My name 14012134885. Fair law enforcement institution. Various court can resolve unlawful act depending of the situation and the perpetrator. According to the law on judicial power, which was enacted in 2009, the power of the judiciary is an independent institution that can be exercised by the Supreme Court and other judicial bodies to uphold the law and justice. Next.
Okay, hello, my name is Abigail Charmen Meteng with students ID 140-1213-586. So I'm gonna explain. The first one is about religious courts. So what is religious courts? It is the authority of the religious courts was established in 2009 through Law Number 50 of 2009 as the second amendment to Law Number 7 of 1989. They have the authority to look into the cases of people who are Muslim and are involved in various fields such as marriage. The next one is about the authority of the military court. Military courts have the authority to investigate and decide criminal cases related to violations of the law or crimes committed by people who were members of the Indonesian armed forces at that time. These cases can only be decided by the courts in the military environment. The third one is about State Administrative Court. The State Administrative Court is a division of the state administration that handles administrative and financial matters related to the government. The State Administrative Court is responsible for hearing cases related to unlawful acts committed by state employees. And the last one, it is about the general courts. So the concept of general justice is one of the main reasons why people seek the judiciary's help when they commit a crime or offense. If the defendant is found guilty, they will be tried in the court that has the power to impose punishment. Various levels of courts are also used to settle cases. Will be continued by my friend.
Okay, so we have analyzed about a case that have been decided by a court and have a fair decision, and this is our analysis about it. So this is about Heri Wirawan, who was accused of raping a 13-year-old girl, was sentenced to death on March 4, 2022. He was given the death sentence due to the provisions of the Criminal Procedure Code. Harry was sentenced to spend a total of 300 million rupiah in restitution to his 13 crimes. He was found guilty following the implementation of Article 81 of the 2016 Republic of Indonesia Law on Child Protection. This includes Article 65 of the 2002 Child Protection Law. And the death penalty and the restitution amount for Heri Wirawan are both appropriate punishments for sexual violence. These actions have a devastating effect on physiological development. According to Yuti Kurnia, the attorney for the victim, Heri Wirawan's death sentence has fulfilled their expectations. However, they still feel that his actions cannot be erased from their lives. So this is the references of our work, and that's all from me. That's all from our group. Thank you for your attention. Wassalamualaikum warahmatullahi wabarakatuh.